Good morning. This is Oasis XP. My name is Sanjay Ratnavel. I'm the president of Oasis. Thank you for joining today. We're joined today by two lawyers from the multinational law firm Faegre Biddle that both of you are based in DC. Welcome, Peter. Welcome, Reed.
Thank you.
We're delighted to have this discussion today really centered on testing of employees and students for COVID-19 and potentially other kinds of diseases in context. And it's been an exciting week. You've obviously heard that we made an announcement regarding a partnership to provide some PCR testing. You should know that this neither Peter or Reed have any connection with Oasis or with Centogene, and it wouldn't be a legal webinar if we didn't start with some disclaimers. So just wanted to put that in here. I found these guys because I was just very impressed by the level of resources that they provided on COVID-19, and contacted them a few weeks back and asked them whether they would share their advice. So with that, just a little bit of framing for you. Obviously, many of our schools are wondering when they should go back and what are the factors that really determine not only going back, but also staying open. And if something happens, you know, what would justify them closing down again and thinking about reopening. In the context of independent schools, I shared with Peter and Reed that there is some sensitivity regarding this issue because of a legal case that took place some years back at the Hotchkiss School, where a $41 million award was made for a student that incurred tick-borne encephalitis on a field trip. And so these kinds of issues have raised their head before, and they touch on many issues, negligence. In this particular case, I suppose they also touch on your liability as an occupier, whether it's for your employees or students or anyone who visits the campus. And so they put together a really great presentation, and I'm going to pass it over to them in a minute. But just in terms of a process here, just sharing my screen very quickly, you should know that basically there is information on our website under COVID-19. We will post the video here for you of the webinar and with some other information, frequently asked questions and stuff like that. The process in terms of asking questions is we will take questions as the presentation goes. So put them into the chat thread, and then at the end, we will also look at people who've raised their hands. So with that, I will pass it over to both of you, and thank you so much for doing this. We really appreciate you. You're muted, Reed.
Thanks so much. Yep, so we're happy to be here and happy to share this presentation with everybody. We'll go ahead and kick it off. We phrased this around COVID-19 testing and return to school. We're going to structure most of this as a series of FAQs, similar to some of the materials that we'll highlight at the end of the presentation that are also available on the firm's website. This is a little bit of background information about who we are. My name is Reed Abrahamson, and I focus mostly on privacy and data security issues in the context of medical information and research and things like that. And I'll let Peter introduce himself as well.
Thanks, Reed. So I'm also an attorney in our Washington, D.C. office, and the focus of my practice is also on information privacy and data protection laws in the US, Europe, and elsewhere. So I help companies comply with data privacy requirements and build privacy programs.
And so then, as Sanjay already gave a couple of these disclaimers, but just to reiterate that this is general background information on the law and scientific issues associated with COVID-19 testing. We're not here representing either Oasis or Centogene, and we're not endorsing any specific products or services. Okay, so before we dove into some of the specific legal issues, we wanted to start with kind of an overview of some of the broader concepts that are applicable in the context of returning to in-person instruction or in-person work. And we've derived the aspects of this presentation from our work with a number of entities across different industries as they think about what it means to come back to the workplace or to come back to a physical location after being remote for a period of time. And really one of the things that we've seen people focus on is the need to develop a plan, or actually it's 3 plans. It's a plan to reopen, a plan to stay open, and then a plan to shut back down again. And the important step here, the important piece of this planning is to make sure that you do all of this in advance, so that that all 3 pieces of this process work together, and that you're not at any point in time put in a situation where you're reacting to events without having decided in advance what the metrics are going to be for your reaction and how you plan on reacting once those metrics are hit. So for your plan to reopen, there's a number of factors here. How are you going to leverage testing options for the presence of the virus? How often will you be testing? And that's going to be dictated both by your ability to obtain tests and pay for them, and also your ability to administer them. And then in between testing, what other screening measures will be used? So that's things like temperature checks, questionnaires, some of the other methods that we're all familiar with. Once you've decided how you're going to reopen, then you need to start thinking about how you'll plan to stay open. So how long are you going to continue the different testing efforts? What will cause you to change testing patterns over time? And what criteria are you going to use to make decisions about either new screening measures, new tests, new safety measures that you want to put in place? And then nobody likes to think about the 3rd plan, but it's an important component of this whole process. And that's, how are you going to plan to shut back down? What are the points in time where you're going to make a decision and say, hey, we've met a certain threshold now, we're going to suspend in-person operations, or we're going to suspend part of our operations, or we're going to suspend all of our operations. And this is not really something that you can plan for necessarily just in isolation. An effective shutdown plan or effective plan around preparing for a shutdown involves understanding what local public health authorities in your area are expecting. It may even involve outreach to local public health authorities and seeing what their parameters are for requiring shutdowns, or what they think would, in their opinion, would trigger the need to shut down. Communicating with other similar entities in your region. So what are other schools doing? How are they going to approach this issue? And really understanding kind of how the community is going to be responding in the event of an escalation in cases. So for example, one of the things that we've seen come up for businesses is, especially if they have a large number of people who use public transportation to arrive on site, their shutdown plan is actually tied to shutdowns in public transportation, because at a certain point people won't be able to get there, and so even if they remain open, they'll be less effective. There's no sort of silver bullet here. There's no magic words that go into these plans. There's no one size fits all threshold for a lot of these issues. But what we've been emphasizing, what we've seen our clients do across different sectors, is really sit down and engage with these issues. And so there are a couple of things that we can share with you just as you're thinking about this. And the first is the importance of a communication approach. So whatever your plan is going to be, however you're going to develop it, making sure that you understand how you're communicating that to the key stakeholders, in this case, your students, your teachers, your other employees. And then also thinking about how are you going to communicate different events during this cycle. So if you have a positive COVID-19 result, or somebody reports an infection to you, how are you going to communicate that out? How are you going to answer questions? Understanding sort of what those different types of outward bound communications are going to look like, and also then developing a response process for any incoming questions and queries. We've also seen a lot of people engage in essentially quasi-market research activities. So taking your plan and, before it's actually announced more broadly, testing it with key stakeholders. So a group of parents, a group of key teachers, and getting feedback. Because throughout this process, all aspects of this are going to work better if all of your stakeholders are bought in, they understand what's going on, and they are supporting the efforts that you're making. If you announce something sort of out of the blue, or it seems like a surprise, or it seems like something that people might be uncomfortable with for some reason, you're going to get less buy-in and you're going to get less support. So having those conversations up front and trying to work with people to develop a better plan has been very important for a number of our clients, both with employees and other stakeholders. Testing plans in advance. We've seen a number of people do tabletop exercises to work through various scenarios. So do people, once you've gotten your plan set, do people know what they're supposed to be doing? Do people know who's in charge at key points in time? Who's supposed to be making certain decisions? Who's supposed to get access to what information and when? There's a component of this also that if you're going to be deploying a new technical solution, for example, if you're going to be using an app that you haven't used before to communicate with staff members or students or parents, testing that and making sure that that works as you expect it to before a go live date. And then finally, and this really could be anywhere in this presentation, at the beginning of this process, at the end of this process, but identifying your team, both internal and external. So knowing who's in charge of making these decisions at each step of the process, who's going to be the decision maker, who's going to be consulted, who has important input that needs to be collected, and how is that going to be weighed and valued, and on what time scale. So are you doing these things daily, weekly, who's involved and when? And then also identifying outside resources. So who in the community do you need to know about your plans? Engaging now with public health authorities or other schools in your area to understand what they're doing, what their expectations are. Talking to others in your region, people at public transportation, people at local health care providers, hospitals, things like that. Just getting a sense of who else is out there in this community, because nobody is making these decisions in isolation. A lot of your decisions are going to be informed by the state of the virus, the state of infection around you, and what other people, including people over whom you have no control, are deciding to do about their own efforts to contain COVID-19. So making those contacts now, setting up so that you're not going in cold and just dialing somebody off a directory the first time an event occurs, but rather calling somebody that you already have a relationship with and with whom you've discussed, proposed processes and approaches. So that's a kind of a general overview of sort of some of the high level things that we're seeing people look at now. Before we dive into some of the more nitty-gritty stuff, maybe I'll just pause briefly for any questions about this overview.
Don't see any in the chat thread right now, Reed.
Okay, great.
I think there are lots of questions regarding the technical stuff too. Lots of questions, so no, please keep going.
Sure, great. Well, then we will dive into some of the FAQs and some of the technical issues. So, Peter, I think, we've heard a lot about testing employees, testing people, that it's an important part of preventing an outbreak or an increase in infections or rebounding cases. Maybe just for everybody's benefit, can you talk through what kinds of COVID-19 tests are available and what they do or don't tell us?
Sure, thanks, Reed. Yeah, so, and I know these questions came up several times on the webinar that was put on earlier in the week. So there are two, at a high level, there are two different types of tests, and the Centogene Oasis partnership is focused on these diagnostic tests, which we discuss on this slide here. So these types of tests are designed to identify an active COVID-19 infection. They are FDA authorized tests. They can be done either through the nose, or I think what is being, the Centogene test is an oral pharyngeal test, so it would be done through the mouth. Essentially a scrape of cells is collected. That's then analyzed at what is called a CLIA certified laboratory. That's the Clinical Laboratory Improvement Act. That's the provision of federal law that governs laboratories that conduct diagnostic testing. And so they are looking for the viral genetic material. And if they find the viral genetic material, then a positive indicator indicates that you are indeed infected and you are actively currently infected, whereas a negative test suggests that they haven't been able to find that viral DNA. So so for these kinds of diagnostic tests, they're considered relatively accurate, and they're a good indicator of whether someone is currently infected and infectious or not. And then the other type of test, which was several questions came up earlier in the week, are these immunoassay tests that are looking for antibodies. So essentially what these tests are looking for is, has someone been infected with COVID-19 and now developed antibodies to fight off the infection? So this is useful in particular in determining whether someone may have developed an immunity to COVID-19 and therefore is the idea would be is safe from further infection. Now the challenge with these tests right now is that the science is sort of at an early stage in terms of showing that the production of the relevant antibodies does in fact correlate with having developed an immunity and therefore being safe from further infection.
Great, and part of the reason why we start with that is because it does impact the different regulatory regimes that arise around the types of testing that are available. The regulators have looked at each of these types of tests and come to different conclusions about what employers may do or require in terms of these kinds of testing, which leads us directly to question 2. Can you test employees or students for COVID-19 or antibodies before having them come back to in-person instruction? Peter.
Yes, so obviously a very important question. And particularly in the employment context, there is now considerable guidance addressing this issue. So an employee medical examination is regulated by the Americans with Disabilities Act. And conducting any kind of diagnostic testing like this is considered a medical examination. The general rule is that an employer should not be conducting a medical examination as part of determining whether someone comes to work, because discriminating against someone based upon a medical condition, based upon a disability, is prohibited by the Americans with Disabilities Act, the ADA. However, the ADA provides that in certain limited circumstances, it is permissible to conduct a medical examination. In particular, it's permissible to conduct a medical examination when a condition could result in a direct threat to the workplace. And based on guidance from the Centers for Disease Control, the CDC, as well as the World Health Organization, WHO, the COVID-19 pandemic does present a direct threat to the workplace, according to the US Equal Employment Opportunities Commission, the EEOC. So that's the federal regulatory agency that oversees compliance with the Americans with Disabilities Act. And they have issued guidance indicating that COVID-19, based on CDC guidance, does presently present a direct threat to the workplace. And therefore, based on that determination, they say it is permissible for employers to collect medical information concerning employees that is relevant to understanding whether an employee might be infected with COVID-19. So that would include asking about symptoms that are commonly associated with COVID-19, as well as doing diagnostic testing to identify someone who is currently infected with COVID-19.
Peter, I think we have a question here, which is,
sure.
is germane to the previous question and is absolutely germane to this one, from Heather Callahan in, I think in Connecticut. Can you talk about the difference between the PCR tests and the POCT antigen tests that are available? PCR testing is better for asymptomatic testing, systematic screening, while the POCT antigen tests are better for symptomatic testing. However, the PCR test is more expensive, so our school is having trouble wrapping their heads around paying for this testing, which has been recommended at standard of care by the state of Connecticut.
Yeah, sure. So again, what this comes down to is there are two different types of diagnostic testing. There is testing for someone who is currently infected and may be infectious, and there is testing to determine whether someone has been infected, they might still be infected, and whether they have developed antibodies. And the antibody testing is testing that they take a blood sample and they determine whether that blood sample contains relevant antibodies. But in terms of the timeline that we're talking about, someone first gets infected, then it takes a period of several weeks to develop those antibodies. So you're infectious during that whole period. So
yeah, I think she's talking more about the antigen test rather than the antibody test. And I'm not sure that this is really something that you want to, I mean, it's up to you, but this is a medical question as much as anything else, because it touches on the specificity and sensitivity of each of these particular tests. Is that something that you feel comfortable answering on?
Yeah, in terms of when we start getting into the different kinds of diagnostic testing for determining a current infection and the different kinds of antibody testing, I'm going to leave that to the medical professionals.
Yeah, I mean, I think that the issue here is the false positive, the false negatives, and the PCR tests have generally been recommended because they have a 95 to 100% accuracy rate on sensitivity, whereas the antigen tests don't. But Heather, I think we can come back to this issue, but really this is more a legal discussion rather than a medical discussion. Keep going.
Sure. So so what has the EEOC indicated is permitted, and what have they advised against? So they've said that it is permitted to conduct diagnostic testing to identify an active infection. And they've indicated that employers have a responsibility to ensure that tests that are administered are accurate and reliable, and they have to follow FDA guidance on test administration. They've also said it is permissible to conduct temperature screening to identify individuals who have a temperature above 100.4, which would suggest that they're ill. It's also permissible to ask questions about symptoms which are associated with COVID-19. And it's also permissible to ask questions about whether someone has been in an area which is known as currently having a higher rate of COVID-19 infections.
So Peter, is taking a temperature and screening in this way, is that considered a medical examination?
So that is considered a medical examination in this context, yes. So what's not permitted? So this gets to these antibody tests, and the CDC has said that antibody tests should not be used to determine who may return to work, should not be used currently to determine whether it is safe for people to congregate in workplace settings or in schools or otherwise. And that's part of the rationale there is simply that it has not yet been demonstrated whether the development or the appearance of these antibodies in the tests actually means that immunity to further infection has occurred. And so you know, the science could change or you know will change over the course of the next several months, but their current position is that it's too early to use these tests these types of tests, the antibody tests, to determine who may return to work or who should be put together in dormitories and schools. And as a result, the EEOC has said it's not appropriate to use these tests to determine who can come to work. So one other point which is mentioned here, which is an important point, is that you may have some employees who have an underlying condition that places them at greater risk, or you may have students who have an underlying condition which places them at greater risk. So you certainly should have a process for those individuals to self-identify to you, and you will then want to engage in a process to determine how or whether you are able to reasonably accommodate their particular conditions that put them at some higher risk. Okay, so student testing. So whereas there's been guidance from the EEOC and at this point plenty of guidance addressing the rights of employers to ask employees to identify if they've got any COVID-19 symptoms, as well as to undergo diagnostic testing. There's been much less that's been written about the rights or ability of schools to require students to similarly indicate whether they have any COVID-19 symptoms, or similarly conduct diagnostic testing before allowing those students back on campus or into dormitories or other school settings. Now, one of the relevant things to note here is that in terms of the ADA, while it's a different section of the ADA, the language is very similar. And so at least arguably, a similar analysis should apply in the student context as it does in the employer context. But of course, because there is no official guidance, it's you know, a bigger legal risk than the employee context where we've got the official agency having given clear guidance. But I would argue that, you know, the same analysis should apply here. So first you'd want to identify that, and you'd want to document that you've identified that there is a direct threat to the educational setting of having students who are actively infectious with COVID-19. And based on that direct threat, identify that you've determined that there are steps that are necessary to take to reduce reduce that threat.
So Peter, the relationship is different with students because students are customers and employees
Sure,
are
yeah.
not, right? And so if the ADA is recommending the same level of screening, filtering, whatever it's called, does that mean that you're able to say that your contractual relationship with your customer has been essentially altered by law or does that not, does the contract that you have with your student get in some fashion altered by that? Because they may say to themselves,
no. So you still have to look back at what your contract with the student says. You know, ideally, particularly for the new school year, you will have now at this point addressed in your contract with the student this kind of a situation. But absolutely, you need to look at what your contract with the student says and make sure you're.
Yeah, this is the biggest issue, or one of the biggest issues for our schools, because basically, you know, online learning is not part of the business model of independent schools on a standalone basis. They're charging usually somewhere between $30,000 to $50,000, and online learning models really basically charge 10. So the question then becomes, if I'm not allowed to go to school and I'm going to be in an online environment, should I be refunded, and all those issues that come with that.
Yeah.
And okay, keep going.
Okay, so I think we've addressed this slide, so let's keep moving on.
So then I think the other question, Peter, is, you know, we've seen this come up a lot, especially in the conversation nationally that's happening around contact tracing and, you know, the different ways and mechanisms that different entities are engaging in contact tracing, some of those done at the governmental level, others which are private solutions, and even in some cases proprietary solutions that are made available to, you know, specific companies or people who sign up for a specific service. But in general, when you learn that someone has tested positive and need to, you know, make a communication or want to make a communication about that positive test to others in the community, may you do that?
So the general answer to that question is no. It is generally not prudent to disclose the identity of someone who's infected or disclose medical condition of an employee or student. As we'll get to on the next slide, there's an asterisk here because there are exceptions to the general rule that are important. So let's go to some of those exceptions. So in terms of employees, employee test results must be kept confidential under the ADA with certain exceptions. So it is permissible to share the information with supervisors and managers who need to understand what restrictions on work duties and necessary accommodations are necessary to to help the employee. You can share the information with first aid safety personnel. You can share it with government officials in connection with an investigation. You can share the information with workers' compensation offices. You can share the information where it's necessary for insurance purposes. And the EEOC has made it clear that you can share the information with public health authorities in line with any local requirements to report this information to local public health authorities.
But when you say insurance purposes, you're not talking about personal insurance, you're talking about general insurance.
Correct, yes, yep.
I mean, personal insurance will put it into the realm of HIPAA, right? And there are some significant barriers to doing that.
Yeah, we'll get to HIPAA later. So I know this particular program we're not charging insurers. We're not billing health insurers for these tests. Yes. So certainly once we'll get to later what the implications of billing insurers in relation to a diagnostic test, what implications that has. Okay, so under FERPA, so well, first of all, let's note FERPA applies to any educational institutions that are receiving funds from the Department of Education. So most private K through 12 schools would not be covered by FERPA because they're not receiving funds from Department of Education. But public schools, public charter schools would be covered by FERPA. So under FERPA, the privacy law that applies to educational institutions that receive public funds, positive results may be disclosed to public health authorities when necessary under the health or safety emergency exemption. So generally speaking, FERPA restricts the disclosure of education records, but they allow the disclosure where it's necessary for health or safety emergency purposes. And guidance from the Department of Education indicates that that exception allows a FERPA-covered educational institution to disclose COVID-19 positive personally identifiable information to a public health authority.
So Peter, what you're saying then is that you're able to test students under the ADA, right?
Correct, yeah.
And you are able to disclose student information that's positive related to COVID under FERPA, but only if you're receiving funds from a public, because some of our schools will be receiving PPP loans, but most of our schools don't receive any money from public authorities.
Yeah, so what I'm saying is if you are a public school, public charter school, then FERPA applies to you, and they have a general restriction on disclosure of educational records. And this information, diagnostic testing information, for FERPA purposes is part of the educational record. And as a result, you need to keep the information confidential, and there are restrictions on disclosure of that information. However, you are permitted under FERPA to disclose information for health and safety where there's a health or safety emergency. So if you're covered by FERPA, that exception will allow you to disclose the information to public health authorities. If you're not covered by FERPA, then the FERPA restriction on disclosure simply doesn't apply. We have to consider whether there might be other restrictions on disclosure. But this first bullet point is is really only relevant to schools that are covered by FERPA.
So would it be prudent or necessary to get consents from students to this testing, or is it particularly for independent schools?
So it is prudent to get consent for the testing as a general matter. The one consideration that we have to give to that question, or the main consideration, is what is the consequence if somebody declines to provide consent?
Yeah.
So what we don't want to do is say, we're going to present something as an option to you, but regardless of whether you sign the consent or not, we're going to go ahead and disclose the information, for example. That results in it looking like a false choice, and it would be preferable in that situation simply to provide a notice indicating what our rights are in terms of disclosure of the information, and indicating that we will be disclosing positive test results to public health authorities.
So I know that's, I've had this question asked to me many times. Some schools are saying, okay, let's say we do a test and someone refuses to do the test, and we say to them, you can't come back to campus, you have to do only our online program, right?
Yep.
Or you say to them, unfortunately, you are going to have to go through more restrictive entrance testing, let's say having your temperature checked for 14 days nonstop or something during a period of potential infectiousness. Is that kind of different treatment allowed?
Well, so this gets back to this ADA question of can you as a condition for entry to campus or building facilities say, we're requiring you to undergo this diagnostic testing? And I think the better answer is to say, you can require that, but we have to be, we have to be under sort of eyes wide open that we understand that there's no sort of official guidance from the government that says that with respect to students. There is official guidance that says that with respect to employers. The relevant sections of the ADA that deal with customers in a commercial setting, which, as you mentioned earlier, is essentially what students are for a private school. It's Title III of the ADA as opposed to Title I that deals with employers. But I'd argue the analysis is the same, but of course, frankly, whether we're talking about an employee or whether we're talking about a student, we also have to look at the relevant contracts. We also have to consider what employment contract there is with the employee, what kind of contract the school has with the students, to ensure that what we're doing is consistent with the contract.
Yeah. Okay.
So the next question, Peter, is kind of a record-keeping question. Both the ADA and to the extent that it applies to anybody on the phone, FERPA do have record-keeping requirements that relate to medical information or student records. How would those apply here?
We have a question that's related exactly to this. Do temperature checks of students
Sure.
and employees need to be recorded daily, or can just a febrile temperature be recorded, documented when discovered? I'm not sure what a febrile temperature is.
Yeah, so so if a student's temperature is, in terms of the temperature question, if a student does not have a fever
Right.
above 100.4, I don't think I can't think of any advantage in recording that information in the record. If somebody does have a temperature above 100.4, then there's been some debate in the legal community as to the advantages versus disadvantages of actually recording that temperature in the record. And I'll explain the debate for you here. Part of the debate is it really necessary for the organization to record that information? And does recording that information simply put them at risk then of having information that they need to keep confidential that could then be subject to a breach or other disclosure? And so the argument there is, let's use the information, let's take the temperature, show the individual that they have a fever, and then let's record simply that they need to stay at home for 14 days, for example. The other side of the argument is, well, we need to record the temperature for legal purposes in the event of potential litigation. So recording the temperature allows us to show at a later time that this individual was not unreasonably disallowed from entering the workplace or just entering campus, but that they in fact had a fever. So, you know, there is a debate in the legal community about that. My personal view is at the least you should record a yes or no answer. Does somebody have a temperature above 100.4 or not? Or you should record a yes answer rather. No answers don't need to be, but.
And you should keep this as a electronic health record as opposed to an educational record, or both?
That's a complicated question. So if you are subject to FERPA, then that information is by definition part of the education record. So if that information is maintained by an educational institution and was collected by or on behalf of the educational institution, it is part of the education record. So by definition, if you're covered by FERPA, that is part of the education record. You may still want to keep that information in sort of a separate locked file cabinet, but it is.
Got it. Peter, we're getting question after question here, so we should probably push through the PowerPoint and get to the questions. Does the temperature check have to be done in private? Is another one I just got.
The results of the temperature check should be private. Yes. You know, you don't necessarily have to do it in a enclosed room, but you should not be sharing that information. You should not be taking the tests in a manner that reveals to everybody around what the...
That in itself is a problem, because most people are thinking of doing temperature checks at carpool lines. And obviously you're not going to let the person in if they got a temperature. So they'll be put into a kind of holding area, or and that in itself is a marker of the fact that they're under suspicion.
Yeah. Well, let's come back and think through that question. But yeah, I see your point.
Okay. Let's keep going, because I think we should take a few live questions, and those would be great to get to.
Okay, well then, briefly, I'll just summarize this, because this is one that I know came up both in the conversation so far today and on the webinar last time as well. Basically the question is, how does HIPAA apply to this? Does HIPAA apply, at all to this kind of testing? And just HIPAA in a nutshell, and HIPAA is pretty complicated, but we'll try to keep it simple, HIPAA applies only to covered entities or business associates of covered entities. In this context, I think the most important bullet here is the first one. Covered entities are healthcare providers that bill insurance for services rendered. So if you are providing healthcare and then billing a health insurance plan for that service, then you become a covered entity. So if you're not doing that, if you're providing healthcare but not billing insurance, then you are not a covered entity and not subject to HIPAA. If that's the case, if you are not billing insurance, then the information you collect is not technically PHI, as that term is defined by HIPAA, which is protected health information, because it doesn't come under the scope of HIPAA because it's not being generated by a covered entity or covered entity's business associate. So for most institutions, unless for some other reason you are already billing health insurance providers for healthcare services rendered, you should not become a covered entity simply by the virtue of the fact that you're paying for tests and then administering them, so long as you then don't try to seek reimbursement from a health plan or other third party for the cost of those tests.
Yeah, this is very
if you are, yeah.
This is very important.
If for some other, if for some other reason you've done that before in the past, either you have an on-site health clinic or you provide health services to students and you bill a health insurance plan for those services, you may have already become a covered entity, in which case this type of activity would still fall under your obligations as a covered entity and it would be PHI. But if you haven't done that before, haven't done that in the past, then this shouldn't change your status now.
Got it. And Reed, I've got questions related to whether such a thing exists as HIPAA certification. Could you address that?
Yes. There are certificates that different independent certification organizations offer that are related to compliance with HIPAA's requirements for security and privacy. However, the Office of Civil Rights at HHS, which is responsible for enforcing HIPAA, has never endorsed any of those certifications, and they've said that they don't rely on them. They assess compliance with HIPAA individually without reference to whether or not certification status has been established. So if they're a useful tool, then by all means look into them, but they don't carry any regulatory or legal weight.
Got it. And a quick question here. What if we collect a specimen, but the lab is billing for the testing? I think what that means is the lab is billing. If the lab is billing health insurance, then it's covered by HIPAA. If the lab is billing the school, it's not covered by HIPAA.
Correct.
Okay, got it. Is the school obligated to test versus sending students to a local testing site? Example might be a very small boarding school with no POC testing, clear wave test, delivering parent level care. I don't think that's related to this, so I think we'll keep going. We'll answer that later.
Okay. So then just to wrap up briefly before we go to the questions, here are two links to resources that are available on our firm's website. The first is the article that Sanjay mentioned at the outset, which is organized as an FAQ, which we put out discussing a lot of the information that's in this presentation at greater detail. And the second is from our labor and employment colleagues who have really put together a very comprehensive guide to a large number of issues, many that go beyond the scope of what we've been able to talk about here on returning to work in the time of COVID-19. That's also linked here in the slide, and both are available from the firm's website.
Brilliant. That was really great. Thank you, guys. I'm going to start recognizing a few people. Put your hands up, please, if you want to talk. I'll start with you, Heather. You've been prolific in your questions. So Heather, can you hear us?
Yes, I can hear you.
Where are you from, Heather?
Avon, Connecticut. I'm at an all-boys boarding school with about 400 students. We have about 300 boarding and 100 day students. So one of my questions, I know I had a few of them in the chat box, but one of them was about paying, whether we as the employer are required to pay for testing for our faculty and student-facing staff. So the state of Connecticut actually put out a guide to reopening for independent schools with guidelines and recommendations, which boarding schools here in Connecticut are assuming is sort of a standard of care that's been set out by the state. And in that, it does say that we need to test students and faculty and student-facing staff 4 days prior, within 4 days prior to returning to campus, and then again 7 to 14 days after, and then at other intervals throughout the school year. And with the PCR testing at $135 per test, it gets very, very expensive for the school to pay for their employees to have this testing done. Yet there's no.
So, sorry, Heather, I can answer the question. So basically, in order for it to qualify under the ADA as something that you're requiring your employees to do, the employer is required to pay for it. If you require the employee to go, you can't require under the ADA the employee to go get a medical test and provide that to you out of their own pocket.
But wait, Reath, wait, hold on. But what about students and parents?
So students and parents would be different, but as to at least as to the, I think Heather was speaking in this context about the faculty and staff. In that context, under the ADA, when they're an employee, then that's how the requirement kicks in.
So, and can the employer tell the student, the employee, to go and get tested and bring the test back and show the test, rather than paying for doing it that way? Or is that? I mean, Heather's talking about a $135 test. I think she's referring to the LabCorp Pixel one. But that's is that okay?
So you could, but then you would not be conducting that as a medical examination under the ADA, and you would potentially lose your ability to require them to do that. So if you're going to have it be a requirement for an employee, then under the ADA, it does have to be paid for by the employer. If you're going to ask the employee to do it and bring the result back to you, just ask them to, but not as a requirement of their job, then it's not a medical examination under the ADA, and it doesn't have to be paid for by the employer.
But we ask people to do TB tests outside and bring them back, right? But it's still not covered, basically, as a medical examination.
In this context, if the EEOC requires that employers pay for medical examinations.
Got it. Heather, do you have any other questions?
Nope, that's all. Thank you very much.
Yeah, and the Oasis Centogene PCR tests are at $88. Other questions? Is a school obligated to test versus sending students to, that's what I just said, to a local testing site? Is a school obligated to test versus sending students to a local testing site? Example might be a very small boarding school with no POC testing, clear wave tests, delivering parent level care. I think that's the same question, right? Let's move on. What if we collect the specimen, but the lab is billing for the testing?
So if the lab is billing insurance, or if the lab is billing the school, then the HIPAA analysis we went through before still applies. If the lab is billing the insurance company that is associated with each patient from whom you collected the test, then we need to just, I think, parse that pretty clearly and make sure that the relationship between the school and the lab was clear to understand how the different obligations flow out. But if the lab's just billing back to the school, then that doesn't create covered entity status.
Got it. And so going back to Heather's question, I didn't realize the state of Connecticut had issued guidelines for this. And if those guidelines are saying that they should be tested, and something happens regarding a case that takes place that is attributable to, that requires a school to close down, do those guidelines establish the standard of care in a negligence situation?
They would probably be persuasive, or at least relevant to establishing the standard of care, yes.
Got it.
Yeah, would probably depend on context, but they would certainly be a relevant factor.
Right. And we haven't touched on any other privacy laws, but there are some other privacy laws. Some of our schools are international boarding schools, and they have international students and international parents. And although the testing would be conducted in the United States, are there GDPR type issues here?
So the GDPR, once someone comes to the United States, even if they are a resident of Europe, once they are in the United States, the data collected about them in the US would not be subject to the GDPR. If that data remained associated with them, if you had someone who transferred, say, between two campuses, once when they were here in the US and they were tested, and then you kept their file with them when they went back, say, to England or to Ireland or some other EU jurisdiction, that file would be subject to the GDPR at that point when it transferred with them overseas. But when they're being tested here in the United States, even though they're a citizen of Europe, the GDPR wouldn't apply to them while they're physically present here.
But what happens if you sent a consent form through the internet to them in Germany or wherever in the UK, right? And they took the consent. Go on.
Yeah, if you sent a form ahead of time and collected information on the consent form prior to their physical arrival here in the United States and collected that information from someone while they were physically in Europe, then yes, the GDPR would apply to the information collected while the person was physically in Europe.
Got it. Thanks. Martha, Martha Ortiz, can you hear us?
Yes, I can. Can you hear me?
Yes.
So my question is regarding students. Can you comment on payment for required tests? So let's say a student tests with temperature or some other symptom. The school says you must be tested in order to return. Who pays for that test? And then who determines when that student can return? Can the school require a second test, for example, to show that there is no infection? And then the student can return. So now there are two tests involved. So in other words, who determines when, who and how determines when the student can return and who pays for necessary testing?
Which school are you from, Martha?
I'm from a school in Bryn Mawr, Pennsylvania.
Got it.
So Martha, I have a very unsatisfying lawyer answer for that, and the answer is it depends. And basically, this goes back to a lot of what we talked about at the beginning, where communication with parents and students about what your plan is really important. So if you decide that you want two tests, if you want a second test to validate, for example, that the student is no longer infectious, communicating that ahead of time and making that decision about whether or not you'll be paying for it or you'll be asking the student to go and get the test and then report it back to you. That's going to be a decision, I think, for you to make. As Peter mentioned, part of that is dependent on what's in your contract with the student. Part of that is dependent on, whether there is, for example, as in the state of Connecticut, as we just heard, whether there's guidance from local health authorities about what level of testing is required before somebody can come back. So it is going to depend. The CDC has issued guidance for both for suspension of isolation when there is a confirmatory negative test and when there's not. So that might be a factor to look at and consider. Basically, what the CDC says is that if you test negative, you can remove yourself from isolation earlier. If you have no ability to test yourself negatively, then you stay in isolation longer. And that's how they've suggested that people handle the issue.
We have a question here, which is, are schools different to general employers in terms of the congregate setting characteristics?
As to the employees of the school, in this context, I don't think so, at least in terms of the ADA and its requirements.
Okay. Great. Any other questions? We just have one other, which is, do you need to be a CLIA certified lab to obtain a PCR sample? The answer to that is yes, right? A highly complex lab, you need to be not just a CLIA lab, correct?
That's correct. Yeah, that's my understanding.
Okay, I think that's it. Listen, this has been a fascinating discussion. We have one more quick question. Can anyone do temperature checks? I think anyone can do a temperature check, right? You don't have to be qualified in any way to do a temperature check. I really appreciate you guys coming and sharing your knowledge. We will post this webinar on our COVID page, along with our other webinars and the documents that Reed and Peter have shared. Thanks very much for attending, and thanks again to everybody. Thanks, Reath. Thanks, Peter.
Great. Thanks, everyone.
Thank you all.
Bye-bye.
Bye.